The top story this evening, the Supreme Court has upheld the Insolvency and Bankruptcy Code in its entirety and upheld its constitutional validity. While dismissing a batch of petitions challenging the IBC, the top court refused pleas to allow operational creditors parity with financial creditors. A batch of 10 petitions had challenged various provisions of the IBC, such as timelines prescribed, the jurisdiction of the NCLAT, the composition and selection of members of the NCLAT. The court disposed all contentions, raising questions on the constitutional validity of Section 29A, which bars defaulting promoters from bidding for their own companies. And it also upheld its retrospective application, which had also been challenged. It upheld Section 12A of the IBC, which allows for withdrawal of insolvency proceedings by consent of 90% of the creditors. The Supreme Court signed off the order saying, and I quote here, "The defaulter's paradise is lost. In its place, the economy's rightful position has been regained." Now, those are strong words and extremely positive for those who have been supporting the IBC and those who have been hoping that it will be an instrument to clean up the bad loan problem of the Indian banking system. To discuss the contents of this order, this 150-page order, we're joined by Mr. M.R. Umarji, former Chief Legal Advisor of the Indian Banks Association, Behram Vakil, founding partner at AZB and Partners, and Shardul Shroff, Executive Chairman at Shardul Amarchand Mangaldas and Company. Gentlemen, thank you very much indeed for joining me. Behram, let me come to you first. What was very interesting about the judgment is an argument by in the order saying that economic legislation is something the courts will not interfere with. I'll just pick up the exact lines, but is that extremely important that the court said it will not interfere too much with economic legislation?
Yes, thanks a lot, Latha. I think that is a very important factor, and all in all, of course, I am delighted, and I think even as you go through the judgment, it's wonderful to read, including the epilogue. So it's covered all the points very forcefully. Okay. And I mean, the only one tiny wrinkle, which I guess we always ask for the moon and stars, is that on 12A, while it's confirmed its constitutional validity, the timing issue, that whether you can come in at the very last minute or even after the game is over, if that had also just been clarified, it would have been paradise. Okay,
what is the confusion exactly about 12A? Does it leave the timing undefined? Is that your worry?
Well, it doesn't go into the timing issue. It doesn't talk about when. It says it's fine, it's, you know, the section holds. Our only concern was that what's normally put in by the Committee of Creditors and the IP is that once the EOIs are in, once the bidding process is put in, people have spent a huge amount of time, effort and money to thereafter come and say that I'm willing to pay up is a bit late in the game. If you are going to pay up, please do it earlier rather than later.
Okay, so hopefully in a subsequent legislation, a time limit will also be put. Do we have Shardul Shroff with us? Okay, we'll just get to Shardul in a minute. Mr. Umarji, I'm persisting with this statement, judicial hands-off qua economic legislation. The reason why I think the court order stating that economic legislation should not be interfered with by the courts is important is that the other part of the case is this February 12th circular of the Reserve Bank. If the court has a position that it will not unnecessarily interfere with economic legislation, should we hold a hope that the February 12th circular, which will be heard on February 4th, will also pass muster?
Yeah, I think so. It would pass muster because ultimately the circular is issued by the regulator of the banks and financial institutions, and it is exercise of regulatory power. It is ensuring that the banks act in accordance with whatever decisions the regulator has taken.
Okay.
And regulator has power to give directions to the banks.
Okay.
So I don't see any difficulty in upholding the circular of RBI also.
Okay.
Eventually, when the matter is heard, as far as that point.
All right. Let me see if I can get that comfort.
And as far as
yeah, so I'll just come to you in a minute. Let me ask Shardul Shroff if he also can draw that comfort from the judgment. Shardul, thank you very much for joining us. You know, the court is quoting chapter and verse, US case law as well as Indian case law to say that economic legislation is something it would not want to interfere with in its paragraph, judicial hands-off qua economic legislation. Given this strong and lengthy argument supporting that economic legislation should be allowed to take its own course, should we draw the comfort that the February 12th circular is also safe?
Yes, I think we should, because ultimately what they have done is they have supported both the legislative process, the regulations made under the legislation, and they have referred to the overcoming of the Lochner doctrine in US and how the court evolved principles where the initial doctrine of protecting property rights and going on the principles of unequal treatment in a very strict way. What the court has actually said is best explained in its last paragraph, where the court says that we are in a stage of experimentation and it is not proper to interdict regulations which are essentially brought in to this thing. In fact, let me read the language. These figures show that the experiment conducted in enacting the code is proving to be largely successful. The defaulter's paradise is lost. In its place, the economy's rightful position has been regained. So this is the driving force that has resulted in this particular judgment. The court is conscious of the fact that if it starts stopping progressive litigation on what they call as iniquities and minor sort of problems that can arise in a experimental legislation, those have not been taken as determining the constitutional validity of the law.
Okay.
So as I see it, they have also, in a sense, they have supported the RBI's definitions on NPA, on doubtful debts. So clearly, at least in relation to the IBC, they have supported the RBI circulars.
Okay. So that will be very important because that will also increase and keep the momentum on cleaning up of the banks. Now, let me come to the important distinction between financial creditors and operational creditors. Behram, key takeaways. Do you think this also strengthens the position of the banks?
Definitely. I think it strengthens the position, very strongly. But Latha, I want to compliment you. I think the point you made about the Feb 12th is a very good one. And I just don't want to count the chickens before they're hatched. But certainly it helps our case. And fingers crossed. But on the issue that you've just raised, yes, again those waters are a bit muddied by some earlier judgments, and the architecture of IBC is very clear that financial creditors do have a superior position. Most of the money put in is from them. And again, as the judgment shows, that they are the people who can judge this and do restructuring best, do viability studies best. So certainly, and it's not something unique to India. In most jurisdictions, that would be the case. So I'm extremely glad that this has been clarified and now free from doubt.
Okay, that's very good. Mr. Umarji, I want to come to you with another issue. The way in which the court has commented on Section 29A it says it's not just related parties, meaning relatives, but related parties would only be those who had a nexus with the promoter and were hence, in a sense, responsible for creating the default situation. You think that, I mean, what are your comments on that kind of a definition of 29A? Is that liberal, is it good, or is it fraught with problems?
No, it is liberal, it is good actually, because a related party who has no connection with the enterprise would be in a position to come out with a resolution plan and submit it to the committee of creditors. And otherwise it was all the relatives were barred from doing that. Instead of that, it will be only those who are connected, were involved in the management of the enterprise, which resulted in the default and company becoming insolvent. They would not have a right to participate in resolution process.
Okay.
But those who are totally unconnected will be permitted, which is good, that it is possible that such relative is extending a helping hand to the promoters to solve their problems,
Yes.
which should not come in the way of resolving the insolvency of that company.
Okay. Well, actually, Shardul, I wanted your comment also on that. Do you think this proactive and slightly liberal, pragmatic interpretation of the word related parties and relatives in Section 29A is a positive development? Because India is a country where corporate India is full of business families and intermarriages. So clarifying that only when there is a nexus, the person is prevented from applying as a bidder is a good thing?
See, let me put it in the context of ArcelorMittal.
Sure.
And explain why this sort of decision has arrived. In the ArcelorMittal case, the Ruiyas had contended that Vinod Mittal and P.K. Mittal, brothers of Ellen Mittal, are responsible for insolvency of their companies, and therefore Ellen Mittal is disqualified in making a proposal as ArcelorMittal. What was pointed out in that context was that there was a business separation between Ellen Mittal,
Yes.
P.K. Mittal, and Vinod Mittal, and they have nothing to do. And Ellen Mittal had nothing to do with the enterprises of
Pramod and Vinod Mittal, yes.
Yeah. So therefore, in a sense, this is amplifying that principle that ultimately the people. So take another example. Take the example of ArcelorMittal having interest and was in management in relation to the Uttam Galva and the Petron, KS Petron companies, where there was a direct nexus to insolvent companies. So what is explained by this judgment is that where a promoter has direct nexuses even beyond the enterprise, that is even beyond the corporate debtor, which is a defaulter or a non-performing asset, it will be disqualified as an NPA. But the example of relatives like, say, P.K. Mittal and Vinod Mittal, who have no nexus with the business, are not going to pose a disqualification. So there is a subtle distinction which the Supreme Court has created that is not a per se rule. It is a rule dependent on showing that there was a nexus with the management of any enterprise which was insolvent or non-performing. So this is what has been clarified in relation to 29AJ. It's a very subtle distinction, and I think it was reflected in the ArcelorMittal matter. And it is there currently also in the ArcelorMittal proceedings pending before the NCLT. So in a sense, that's brought a quietus to those proceedings, that it is not as if it's an absolute rule. It is a rebuttable rule based on the principle that there is no nexus in the business, and I am not the same person who is responsible for insolvencies of my brothers or relatives who are not connected with my business.
Okay. Yeah, I thought that subtle distinction proactively being brought by the court and explained, in its language was a positive. Behram, you want to add to this? Is that a positive development of case law on IBC?
No, I completely agree with Shardul and Mr. Umarji. I think it's definitely positive because it makes plain sense that if there's no connection with the business activities, whether in the case of the Mittals or several others that we are aware of. I think it's a very helpful clarification. And very quickly, Latha, if I may, I think on this 29A, again, it's, caused so much litigation. If we look at that figure, the famous epilogue, about 2.5 lakh crores, so 25% of the entire NPAs have been recovered in this 18 months, taking June as the real kickoff period for IBC. So one, it's a phenomenal success, and more than half of that has come what we now call pre-NCLT. So because of the threat of IBC proceedings, people are coming and settling. And that is primarily, we know, because of 29A, because who wants to lose their company? So rather than that, you make a sensible settlement. So it has served, it's created a wonderful behavioral change. So I think that should not be lost sight of. And one other super quick clarification about this operational creditors not having a say. It's a terrible thing. The data does not show that. The data shows that overall recovery is very close to 50%, about 48.6%. And in fact, the operational creditors are marginally higher than the financial creditors. And once again, this is from the NCLT. In most cases, I'm sure you'll agree that if it's in matter of lakhs, the operational creditor gets paid off immediately and you don't risk your company for 20, 30 lakhs or even a few crores. So operational creditors have got a much bigger voice now thanks to IBC.
Okay. I actually wanted to start off on the operational versus financial creditors for greater detail. Let me toss that to Mr. Umarji. Mr. Umarji, you think now that is made crystal clear and we should not have any further problems? Is that again a positive development of case law?
Yeah, it's a very good development because you see IBC is becoming a tool in the hands of operational creditors to recover their dues. And by giving just a note, they are required to give a notice to the borrower, to the company, to demanding payment of their dues. And that immediately after receipt of that notice, there will be an effect. The company, instead of facing an insolvency proceeding, would like to settle with the operational creditor and clear his dues. And that has started happening in practice. So the operational creditors are deriving a lot of benefit out of the operation of this law. And the other aspect is that in ultimate analysis, operational creditors' rights are to get liquidation value of all the assets of the company.
Yes.
They can't get anything more in terms of the other provisions of the law, where the secured creditors, the workman dues, and other priorities are laid down, and as per that priority they can get liquidation value.
Okay.
And a further clear provision has been made which says that when a resolution plan is prepared, the first payment is to be made to operational creditors, which can't be less than liquidation value.
Yeah. Okay.
Now all these provisions are protecting the interests of the operational creditors, and there is no need to do anything more than this, because otherwise they can't expect to recover anything more.
Okay.
And the other angle in this is that if I am an operational creditor supplying something very essential to the company for manufacturing process, the bidder for the resolution plan would himself enter into an understanding with the operational creditor so that he continues to get the supply of that raw material.
Yes. Fair point, of course.
And it is happening in practice that...
Go ahead, sir.
And the resolution applicant will ensure that the interests of the operational creditors are satisfied so that they continue to supply essential services and goods to them so that they can continue the manufacturing activity.
Okay. Well, gentlemen...
operational creditor rights are adequately protected. There is no need, there won't be any issue of further amending the law for modifying the rights of operational creditors.
Point taken. Actually, I have had to take a commercial break. We are back in a jiffy, gentlemen, and I want some closing comments from you.